Good morning. This is cause number 2005-52329. In the interest of John, Hannah, and Catherine Guston, please raise your right hands to be sworn. Parties. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
All right, ma'am, please state your name and your relationship to the children.
Amy White, mother.
All right, sir, your name and your relationship to the children.
John Guston, father.
And for the state,
Andrea Perard.
we've got a non-agreed child support review order. We're having a hearing. Do we have any stipulations?
We do not, Your Honor.
All right, let's proceed then.
Thank you, Your Honor. Your Honor, the state would ask you take judicial notice of the final decree of divorce signed on or about April 6, 2006.
All right,
Specifically, that Ms. Guston or Ms. White was ordered to provide health insurance on page 16, and I'll direct you, Your Honor, to beginning on page 16 of that court order.
page 16.
Yes, Your Honor. (16) through 18 for your records.
All right, but she was ordered to provide medical support and health insurance.
Correct, Your Honor.
Okay.
Thank
And
you,
he
Your
was
Honor.
ordered to reimburse at $190 a month.
That's correct.
All right. Is that the issue?
Yes, yes, it is, Your Honor.
That the only issue?
Yes, well, the arrears judgment based on that obligation.
All right, so cash medical support and arrear. All right, proceed.
And Your Honor, the state would also ask you take judicial notice of the non-agreed child support review order that was filed on September 23rd of 2019.
All right,
And Your Honor, at this time, the state would call Ms. White.
okay.
Ms. White, in regards to the non-agreed child support review order that you entered into on September 17th of 2019, you were asking to confirm that order as drafted. Is that correct?
Yes, I believe.
That order specifically confirmed Mr. Guston was in medical support arrears in the amount of $22,952.20 as of August 31st of 2019. Is that correct to your understanding?
Yes.
Okay. And in that order, he was also ordered to pay that judgment back at a rate of $166 beginning October 1st, 2019. Is that your understanding?
Yes.
Now, those arrears were accumulated by the ongoing child support obligation of $190 that was beginning May 1st of 2006 per your divorce decree. Is that correct?
Yes.
And in that divorce decree, you were ordered to maintain the health insurance. Is that right?
Yes.
Did you, and that was from 2006 of May 2006 all the way through emancipation of June of 2019. Is that correct?
Yes.
Okay. And did you always maintain the health insurance for the children from that during that time period?
Yes.
Was that order ever modified to change who was ordered to cover the health insurance?
No.
And did Mr. Guston ever pay you the cost of that health insurance through the state disbursement unit?
No.
Did he ever pay that to you directly?
No.
Now, did Mr. Guston ever cover health insurance as well?
Yes, he did.
Now, according to your divorce decree on page 18, number 5, there is an indication of secondary coverage. Are you aware of that? And it's,
Am I aware that he had secondary coverage?
yes.
Yes, I am aware he covered the children.
Okay. And in that order, that secondary coverage require that if a party provides it, it is at his full cost. Is that your understanding?
Yes,
And so with that, it was your understanding there was an agreement that if he was going to carry it, he was doing that at his own sole cost and will, but you were still covering the private health insurance, correct?
correct.
And that he would still be ordered to reimburse you for the cost of that at $190 per month.
Correct.
Your Honor, I pass this witness at this time.
All right. Mr. Guston, do you have any questions for Ms. White?
Actually, I do, yes.
Go ahead.
You answered yes to did you always provide insurance for the children, and I don't believe that to be the case. Do you have documentation that you provided insurance from the beginning of our divorce?
I do. I have been employed. I know you stated I was unemployed when we got divorced, which is actually not true. I was employed at MD Anderson since September of 2005, which is why your attorney put that clause in. I did not have one representing me, requiring me to cover insurance. So yes, I did cover insurance, despite the fact that you covered them as well, because I was required to. I have never been unemployed. I have always had insurance through my employer.
Okay, but you also said on Friday that you had always worked at hospitals, but I know that you worked at a company called Texas Headhunters years 2008, 2009, which is after our divorce.
You're right, and I was insured through
believe.
them as well. I actually handled the insurance at that company.
Okay. I also recall through a verbal agreement that we had that you would be providing the insurance as secondary since I was providing the primary, and you continued to use my insurance as primary up until the later years,
Again,
and always insisted
What is
that
the
I
question, sir?
provide.
What is the question, sir?
The question is, are you sure that you were providing yours as primary and mine was secondary? Because I believe that you were using mine as primary.
so let me explain. I don't get to choose. When we both cover the children, insurance decides which is primary. They use a rule called, it's something to do with our birth dates. And if they're both covered and your birth date falls before mine, which yours is in April, mine is October, then your insurance is filed first. That's not my choice. That's how insurance works. So I was required to provide both insurances. They were required to file with yours first and then mine second.
Okay, news to me. I don't have any more questions for Mrs. White. Then I do have a few things I'd like to say when I do get a chance.
All right, I'll let you do
in
that.
my-
I'll let you do that at the end of the hearing, sir. Go ahead.
Okay, thank you.
Next witness.
Yes, Your Honor. The state calls Mr. Guston. Mr. Guston, according to the non-agreed child support review order, you are not in agreement to the judgment of the $22,952.20. Is that correct?
That is correct.
Okay. Is your belief that you owe zero medical support arrears. Is that correct?
That's correct.
And that's based on that you indicated that you provided coverage for the children through your own insurance. Is that right?
Yes, correct.
And you provided insurance from May of 2006 through June 2019?
Yes, I actually still currently provide it.
Okay. And you understand that the court order from 2006 orders the Miss White to carry the health insurance, correct?
I do understand that, yes.
And that and in that order, you were ordered to reimburse at $190 per month, and that order's never been modified, correct?
Correct.
And also you understand that the person who is ordered to carry the health insurance per a court order is considered the primary coverage. Do you understand that?
I do understand that now, yes.
Okay, and so the secondary coverage, according to clause 5 that you covered, would be covered by you at your sole cost and expense according to your order.
Correct. I understand that's what's in writing. That's not really what was agreed upon, and it wasn't enforced until 2015. So there's some discrepancy there in terms of the intent.
Okay, so you have indicated that there was a agreement between you and Miss White verbally, is that right?
Yes.
That you would cover health insurance in addition to her or in place of her?
That I would be the primary. The secondary insurance didn't come up until years later.
Will you understand that unless you change that in a court order, the court order is the binding agreement, correct?
I do understand that, yes. The problem is that I didn't realize that was still in the divorce decree. And at the time that we went to court, there was the decree was written by our attorney, and my wage withholding order was written by the attorney for child support, but nothing was written for medical support. And for 10 years, it went on unnoticed until the Attorney General's office noticed it when they went to adjust child support when our oldest child graduated from high school. And at that time, sorry?
At your request.
I can't
It
understand you,
wasn't
I'm sorry.
unnoticed, it was uninformed.
Ma'am, you're not to speak at this point. I'll let you say something at the end of the hearing, all right? Go ahead, Ms. Perard.
Mr. Guston, you understand the attorney who drafted this order was your attorney, correct?
I hired him, yes, but he was representing both of us.
You can't do that, sir. That's against the ethical rules. You can't represent both parties in a divorce.
And according to
Okay, well,
28 of your order, it clearly states that Mr. Perwin was the attorney for John Curtis Guston, respondent, correct?
yes, that is technically correct, yes.
I pass this witness, Your Honor.
All right, do you have any questions for him, Ms. White?
No, I do not.
All right, anything further, Ms. Perard?
Nothing further, state rest, Your Honor.
How did you arrive at the $22,952.20 in arrearages?
That is the amount of arrears according to our pay record at the time, Your Honor.
All right. All right, Mr. Guston, something you wanted to say now?
Yes. The problem that I have with this is that it wasn't brought to the forefront until 2015. And at that time, I was then put in arrears for 10 years of not paying this money. I've paid it ever since then. I've paid every cent of child support that I was required to. So why wouldn't I have paid this if I had known that I owed it? And if I ever got behind on child support, which I did a couple of times when I was unemployed, Miss White was very vocal about what I owed her, but she never ever mentioned that I was behind on medical support until she was made aware of this at the same time I was in 2015. So that to me says that she understood that I didn't owe her the $190 a month, but she saw the opportunity when the Attorney General's office brought this to light to then collect on an opportunity there.
All right, Ms. White, anything you want to say now?
Yes, because it wasn't enforced does not mean it was unnoticed. Similar to the 50% of their healthcare costs that you were required to pay that I never got reimbursed for and stopped submitting them to you because I simply just didn't have the time to deal with it or to go through getting it enforced. But I always knew that you owed the medical So I hoped that would cover part of that 50% of their medical expenses that I never got reimbursed for. So because it was unenforced does not mean it went unnoticed. That's all I have to say.
Ms. Farrar, do you have any final argument on this?
Your Honor, the state would just ask that we, I understand both parties' situation, the state's position to follow the law. And the law is that the order is what the order is, Your Honor, and that there was no modification of that order. If there was a agreement between the parties that should have been put through a modification, it was not. And so we're just simply asking to enforce what the order said.
All right, the court finds that there are arrearages and awards a child the cash medical support arrearage judgment in the amount of $22,952.20. We paid at the rate of $166 a month beginning September 1st, 2020. You may order.
Thank you, Your Honor. May we be excused?
Yes.
Your Honor, could I request that that not be counted on my credit report as delinquent?